Hey everybody, how's it going? Welcome back to Copper Jacket TV. So I was really hoping for a good start to the week, a good solid Monday. But unfortunately, the Supreme Court has decided to betray us once again. So after waiting for nearly a full year since both of these cases petitioned for cert back in August of 2024, the Supreme Court has just denied cert in both Snope and Ocean State. And in Snope, the denial was written by Justice Kavanaugh. The dissent, of course, was written by Justice Thomas, and we have a lot to talk about here between those two letters. So let's go ahead and get to it. Now, this is definitely one I want to hear your opinion on. Make sure you leave a comment down below and let me know what you guys think about today's decision and whether or not you still have faith in the Supreme Court or think they're going to take one of these cases ever in the future. Also, if you haven't done so already, hit that subscribe button. It's free. It only takes a second, but it really does help us out here quite a bit. Okay, so let's go ahead and talk about what's going on here. So I have spent a significant amount of time talking about both Snope and Ocean State since they were originally petitioned to the Supreme Court back in August of 24. They have been conferenced since late November of 2024, and we have been waiting ever since to find out what the Supreme Court was going to do. Now, over the past few weeks, I've decided not to do any updates on Monday like I typically do because the Supreme Court just wasn't moving on anything. But in my last video, I did mention that we are getting really close to the summer break, and if it didn't make it by summer break, which is near the end of this month, then the cases would just end up being denied anyway. Well, they ended up getting denied a little bit early to my surprise because to me, Snope was probably the best so-called assault weapons ban case that has been before the Supreme Court as of yet. It was a case that was completely finished. It was a case that was done. It was ready for them to be heard. The appellate court said that they're not even protected by the Second Amendment because they're too close to what's being used in the military, and so they're not offered any protection whatsoever. And this was something that absolutely had to be corrected by the court. When it came to Ocean State, I was always kind of up in the air because that's an interlocutory case. It's still going on at the lower court level, and the Supreme Court doesn't like to take cases like that typically. But then they dragged that one out too. So we were all kind of waiting to see what they were going to do with both of these cases. So like I said before, Justice Kavanaugh wrote the denial. And in his denial, which we're going to take a look at here in just a second, he pretty much makes the case for why they should have taken this case. He even says that just because they didn't take the case doesn't mean that they agree with the appellate court's decision. He even basically says that AR-15s are in common use for lawful purposes, just like handguns were when the decision for Heller came out. And so he makes comparisons between Heller and so forth, and even points out that the lower courts really didn't follow Supreme Court precedent at all. And so, it's incredible that he wrote that in a denial. The Supreme Court needed to fix this, but they didn't. Then you have Justice Thomas in his dissent, who just basically completely went off and said that as long as the Supreme Court decides not to take these cases, the Second Amendment will remain a second-class right. Let's go ahead and start off by taking a look at Justice Kavanaugh's denial here. Okay, so here's a look at the court's denial written by Justice Kavanaugh. We're going to read the entire thing. It's not very long, and I read kind of fast, so we should get through this pretty quickly. But I want you guys to pay attention, very close attention, to the very last paragraph here. So it says, the petition for writ of certiorari is denied. Justice Alito and Justice Gorsuch would grant the petition for a writ of certiorari. The statement of Justice Kavanaugh respecting the denial of certiorari. In D.C. v. Heller, this court ruled that the Second Amendment must be interpreted in light of constitutional text, history, and tradition. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Because handguns are in common use by law-abiding citizens, the court held that the District of Columbia's ban on handguns violated the Second Amendment. The court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historically based common use test with respect to the possession of particular weapons. And then it says, see these different cases. This case primarily concerns Maryland's ban on AR-15s, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million, and AR-15s are legal in 41 of 50 states, meaning that the states such as Maryland that prohibit AR-15s are something of an outlier. It says AR-15s traditionally have been widely accepted as lawful possessions, given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles. Petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment under Heller. My God. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. So basically, what he's saying right there is that the courts in Maryland got it wrong. He's saying that himself, but they still decided not to take it. So it continues. Under this court's Second Amendment precedents, moreover, it can be analytically different to distinguish the AR-15s at issue here from the handguns at issue in Heller. AR-15s are semi-automatic, but so too are most handguns. Semi-automatic handguns and rifles are distinct from automatic firearms, such as the M16 automatic rifle used by the military. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense in the home. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of the murders and other violent crimes that individuals commit in America. In short, under this court's precedents, the Fourth Circuit's decision is questionable. So he admits it right there. Although the court today denies certiorari, and denial of certiorari does not mean that the court agrees with the lower court's decision or that the issue is not worthy of review, the AR-15 was recently decided by the First Circuit, is currently being considered by several, the AR-15 was recently decided by the First Circuit and is currently considered by several other courts of appeals. And then it lists a bunch of other courts of appeals that have pending cases, one of those being Miller out of the state of California. It continues to say opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certiorari will likely be before this court shortly, and in my view, this court should and presumably will address the issue soon in the next term or two. What in the actual F? I mean, this denial reads like a dissent. It is basically a case for why the court should have taken this. They are saying that they are in common use for lawful purposes. That means that they're protected by the Second Amendment. They're saying that the lower courts defied Bruin, defied Heller, that they probably got it wrong, but we're not going to take it anyway. We might take one in the future. There's several other cases that are going to be coming to us soon, we expect. So they know that the lower courts are probably going to side against the Second Amendment here, but they've decided not to take it anyway. We might take one in the next term or two, but in the meanwhile, you're allowing people's rights to be infringed on by simply ignoring the issue at hand. I mean, you have said yourself in this letter that the lower courts pretty much got it wrong, and that they did not follow Supreme Court precedent. This is mind-boggling. Okay, so here's a look at Justice Thomas's dissent. We're not going to read the entire thing because it is kind of long, but I do want to point out a couple key paragraphs here. So it says, Justice Thomas dissenting from denial of certiorari, the state of Maryland prohibits ownership of AR-15s, the most popular civilian rifle in America. The petition presents the question whether this ban is consistent with the Second Amendment. The Fourth Circuit held that it is, reasoning that AR-15s are not arms protected by the Second Amendment. I would grant certiorari to review this surprising conclusion. The Second Amendment guarantees, quote, the right of the people to keep and bear arms, end quote. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment's plain text covers his conduct. And then they point out Bruin. Once a challenger makes that showing, the Constitution presumptively protects his conduct, and the burden shifts to the government to demonstrate that its regulation is consistent with the nation's historical tradition of firearms regulation. If the government fails to make that showing, the restriction must be deemed unconstitutional. It is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework. To start, AR-15s are clearly arms under the Second Amendment's plain text. In D.C. v. Heller, we held that the term arms is the context covers all weapons of offense or armor of defense. And he also puts the original meaning here, explaining that arms include anything that a man wears for his defense or takes into his hands or useth in wrath to cast or strike at another. Thus, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. AR-15s fall squarely within this category. Because AR-15s are arms, the burden shifts to Maryland to show that banning them is consistent with this nation's historical tradition of firearms regulation, which again, they cite Bruin. But I am not aware of any historical regulation that could serve as a proper analog to Maryland's ban. Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons, and then they reference Heller, see brief in opposition, blah, blah. Under this tradition, however, a weapon may not be banned unless it is both, okay, so this is where he says now that it has to be both, dangerous and unusual. And then he cites Quintano. Weapons in common use for self-defense today and other lawful purposes remains fully protected, which comes from Bruin. And AR-15s appear to fit neatly within that category of protected arms. Tens of millions of Americans own AR-15s, and the overwhelming majority of them do so for lawful purposes, including self-defense and target shooting. Now, the last thing that Justice Thomas says in his dissent is, until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That is no constitutional guarantee at all. I respectfully dissent. Now, I apologize for reading so much. I know that some people don't like that, but I figure after waiting for this many conferences, after waiting this many relists, and then for them just to be denied, we deserve answers. And the only answers that we're going to get are in the court's denial. So, again, it's absolutely ridiculous. I mean, they are arms protected by the Second Amendment. Kavanaugh, Thomas, everybody says it. So why not take this and fix the problem that was created by the lower courts who did not follow your precedent? They are the lower courts. They are the inferior courts. And yes, you should correct mistakes that they made. Tens of millions of Americans are having their rights infringed right now because you have decided that you're just not going to act on these. Instead of accepting them, fixing the problem and taking this on, you've decided to just simply kick the can down the road, and maybe we'll take one in the next term or two. Again, allowing tens of millions of Americans to have their rights infringed when you clearly see that they are. I mean, you make it very evident, even in your denial, that you can tell that people are having their rights infringed on. It is absolutely absurd. I am extremely upset right now. The Supreme Court needs to be ashamed of itself. They should be ashamed of itself. I think that a lot of people have just completely lost faith in the Supreme Court and their ability to actually uphold the Constitution. So even though I've completely lost faith, I still want to let you guys know that the Duncan case out of the state of California dealing with mag bans is heading up to the Supreme Court very, very soon. Whether they'll take it or not, again, it's up for debate. And then, of course, there's Miller out of California and several other cases that people have brought forth that are at the appellate court level that could be heading up there soon, dealing with everything else. So even though, again, I just lost faith in the court altogether here, and I don't know what they're going to be doing in the future, I still want to let you guys know that more cases are still going to continue to keep going up there until this problem is solved. So anyway, I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, please subscribe to the channel. Thumbs ups are always appreciated, and leave a comment down below. Let me know what you guys think about what happened today.